Good.
Madam Deputy Registrar, would you please call the matter?
Thank you, President. Caribbean Court of Justice, Appellate Jurisdiction on appeal from the Court of Appeal of Guyana. Case Management Conference in CCJ application GYCV number 2 of 2020 between Mohammed Irfaan Ali, Barrett Jagdale, and Eslyn David, Chief Elections Officer, Chairman of the Guyana Elections Commission, the Guyana Elections Commission, the Attorney General of Guyana, Mark France, Daniel Josh Kanhai, Lennox Schumann, Shazam Ali, and Abidin Kindi Ali. The court's full bench sits today comprising their honors, Mr. Justice Saunders, President and the presiding judge.
Good afternoon, Counsel.
Mr. Justice Witt.
Good afternoon, Counsel.
Mr. Justice Anderson.
Good afternoon, Counsel.
Madam Justice Rajnot-Lee.
Good afternoon, Counsel.
Mr. Justice Barrow.
Good afternoon, Counsel.
Mr. Justice Burgess.
Good afternoon, Counsel.
And Mr. Justice Jamada.
Good afternoon, Counsel.
May we have the appearances, please? Thank you.
Devendra Kissoon, association with Mahabir Anil Nandalal, Sanjeev Gatadin, Marcy Nadir Sham, Theresa Haddad Maraj, Rishi Das, and Clay Hackett, all being led by Douglas Mendez, Senior Counsel. On behalf of the applicants, Dr. Muhammad Irfaan Ali and Dr. Barrett Jagdale.
Good afternoon, Bonds. I, Keith Scotland, along with Mr. Timothy Alphonse and Mr. Rondell Keller, are led by Mr. John Jeremy, Senior Counsel, Mr. Royce Dave Ford, Senior Counsel, instructed by Mr. Meyer Robertson, on behalf of the first respondent, Eslyn David.
May it please your honors. Kim Kite Thomas, Your Honors, I appear on behalf of the third named respondent, Chairman of the Guyana Elections Commission.
Yes, thank you. Could we have the appearance of the Guyana Elections Commission? I take it there's no appearance on behalf of the Guyana Elections Commission. Then, Mr. Attorney General, can you please enter your appearance?
Thank you. May it please your honors. The Attorney General appears in person with Attorney at Law Mr. Justin Simon, QC, and the Solicitor General, Mr. Nigel Hawke.
Yes, thank you. Mr. Ramkaran, are you appearing for the 6th, the 8th respondents?
Thank you, Your Honor. May it please Your Honors, with Mr. Timothy Jonas, I appear for Mark France, Daniel George Kanai, and Lennox Schumann, the 6th, 7th, and 8th respondents.
Thank you. Is there any appearance for?
May it please Your Honors, I am Kashir Khan and I appear in association with Mr. Mohammed Khan and Mr. Kalesh Lokman for the 9th and 10th respondents, Shazam Ali and Abidin Kindi Ali, respectively.
Thank you. What's the name again, please?
Kashir Khan, Your Honor.
Mr. Khan. Okay, I gather that there's a problem with my video. I'm trying to adjust it, but I'm having a little difficulty.
We are seeing you now, Your Honor.
Okay, great, thank you. So there's no appearance for the Chief Elections Officer and for the Guyana Elections Commission. Is that correct?
That's correct. That is correct, Your Honor.
Okay, thank you. Just a couple of housekeeping matters. The video screen that you're seeing has a feature for you to raise your hand in the event that you wish to say something. And I'd appreciate that you use that feature if it is necessary for you to intervene at any point. I'd appreciate also, as you've been told already, if you would keep your microphones on mute until you are going to speak. Now, this case management conference, it's a case management conference. We did not intend to delve into any substantive issues, but rather to determine exactly what would be the processes that we would adopt in order to have this matter heard. Now, I note that a couple of things. One, a second case was filed. I'm not sure why that became necessary. I am thinking that perhaps the better approach is that we allow that case to abide the outcome of the case which was filed by the side that lost at the Court of Appeal, because unless there's something said to the contrary, I really couldn't understand, we really couldn't understand what new did that second case raise that would not be resolved when the issues in the case that was filed first is fully determined. Perhaps the applicants for that case could tell us something.
If it pleases the court, I do not have any objection to the court's intended course of action, save and except that as it relates to the grounds that I have pleaded in my application, that I be allowed some latitude in responding to the various affidavits and submissions that are going to be made in what would now be the principal and only application, that I be allowed to canvass those as part of the principal proceedings.
Yes. Well, as long as they're relevant and germane to the principal proceedings, then of course you will have the opportunity to do so.
Most grateful.
Okay. The next order of business is that we received 2 applications, one on behalf of APNU/AFC to appear in these proceedings today as amicus with a view to intervening in these substantive proceedings. And we similarly received a request to the same effect from Mr. Hossain, Fayad Hossain, on behalf of the United Republican Party. And we are going to suggest that, well, let me put it this way. Is there any objection to these parties to appear as amicus?
Your Honor, speaking on behalf of the intended appellants, we have no objection to them appearing amicus today, and neither do we have any objection to them being joined as parties in the proceedings, subject, of course, to the convenience of the court.
Yeah. Well, I tell you what, we were thinking, we have a number of respondents, and I believe everybody would want to say something, that the Chief Elections Officer has not appeared and the Guyana Elections Commission has also not appeared. Would open up some space in terms of the timetable that we had already crafted. My original thought was to allow these amici to make written submissions only, but in light of the slots that have been opened up, so to speak, is there any objection for them to also make oral submissions on Wednesday when we propose to hear the substantive case?
Your Honor, again, we have no objection to them making oral submissions as long as that doesn't result in our time being cut down as the appellants in the case.
Yes, no, it wouldn't. Could we hear from perhaps the Attorney General? Is there any objection on your part?
Necessarily, Your Honor, but Your Honors will be aware that the Attorney General has filed an affidavit in opposition, and we're hoping that the court will determine its jurisdiction before proceeding to any formal hearing.
We'll come on to that. What I wish to find out from you.
Your Honors, I have no objection to the APNU and URP being joined.
Mr. Jeremy? Or Mr.
No objection. No.
Okay. So we will order that the APNU/AFC and the United Republican Party, represented respectively by Mr. Amor and by Mr. Hossain, be given leave to intervene in the proceedings. And as we go along, we will indicate the manner in which we will participate. Now, we have the special leave application filed by Mr. Ali and Mr. Jagdeo. In the interest of time and given all the exigencies, we propose that we approach this application for special leave and the objection to it. And in the event that we were to grant the special leave and overrule the objection, the substantive appeal and the arguments for and against that substantive appeal, that we consolidate all of these things in one hearing on Wednesday, so that on Wednesday we would receive from you both your written submissions on whether special leave should be granted or whether an objection to special leave should be granted. And in the event that special leave is granted, what are the arguments on the substantive appeal? And on the other side, what are the arguments opposing the substantive appeal? We would wish you to make your written submissions to cover all of those things in one document. Is that understood?
Yes. Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor.
Okay. So this would mean that we are proposing to have this matter heard on Wednesday, this coming Wednesday, commencing at 9 in the morning. And it would appear to us that the principal issues are: one, whether the Court of Appeal had jurisdiction to entertain the application that was made to it. Secondly, if the Court of Appeal lacked such jurisdiction, what is the consequence of this in relation to the proposed appeal to the CCJ? Thirdly, if the Court of Appeal had rightly assumed jurisdiction, what is the consequence of that in relation to the proposed appeal to the CCJ? And fourthly, if the Court of Appeal rightly assumed jurisdiction and it exceeded its jurisdiction, what is the consequence of that in relation to the proposed appeal to the CCJ? It seemed to us that those four issues captured all of the submissions, arguments, points that we have seen so far. And if there is a contrary view, then we would be pleased to hear it.
Your Honor, it may please Your Honors.
Yes, Mr. Williams.
Just a clarification, Your Honors. So does this mean that the court wouldn't ab initio deal with the issue of whether the court would decline jurisdiction in the matter?
Well, whether this court should declare jurisdiction.
Yes, Your Honor.
Yes, well, that would be covered by points 2 and 3, because if the Court of Appeal lacked jurisdiction, then what is the consequence in relation to the proposed appeal to the CCJ? And if the Court of Appeal rightly assumed jurisdiction, what is the consequence in relation to the proposed appeal to the CCJ? In each of these issues, you will be free to argue, naturally, that this court, perhaps whether the Court of Appeal had or did not have jurisdiction, does not have jurisdiction. So that I think that the questions as framed allow you complete freedom to argue that point.
Most grateful, Your Honors.
Yes. Now, we are on a tight time frame because naturally everybody would like to have this matter over with as soon as practicable. We would like the written submissions to be in, all the written submissions to be in by Monday at 4 p.m. And we do not want submissions that go on and on and on that are repetitious or delve into matters which are not particularly relevant. We think that your submissions could be succinctly captured in no more than 10 pages, each page with a spacing of at least 1.5. And so we would ask the applicants, that is Mr. Ali and Mr. Jagdeo, to make their written submissions on those 4 issues that we have framed by Saturday, no later than Saturday at 9 a.m., which will give the respondents and the 2 friends of the court, well, by then they would be interveners, the possibility to respond to those submissions by Sunday at 4 p.m. It's only one set of submissions so that you have all of Saturday, all of Sunday up until 4 p.m. to respond and file and serve your responses to the submissions of Mr. Mendes and his team. And then Mr. Mendes, you and your team would have until Monday at 4 p.m. to reply to the various responses which would have been filed by the respondents and the interveners. Now, yes.
Your Honor, given that we will be responding to more than one, and probably, as it seems to be turning out, at least 3 sets of submissions that would be against us, as I can anticipate, would you give us until 9 a.m. on Tuesday instead of 4 p.m. on Monday to respond to those submissions?
Okay, 9 a.m. on Tuesday.
I imagine, Mr. Mendes, that you asked for that extra time out of an abundance of caution, since we have seen your submissions already. We have seen the Attorney General's affidavit which contains substantially the submission. We have seen another affidavit which I think contains substantially the submission. So it really does seem that you all have this matter fully covered already.
Well, there's a good reason for caution, because we have 2 very creative senior counsel who are now joining us, Mr. Armour and Mr. Simon. And of course, Mr. Hussein would also be making his submissions, although I don't anticipate I would have to be opposing him. But certainly with regard to the other 2, there may be other things we would have to attend to that may not have been dealt with already.
Then I say no more.
Yes, so we give you, well, we give you until Tuesday at 9 in the morning. It'll put us under a little pressure, but I understand. And naturally, if you can get them in earlier, then we will rely on you to get them in earlier.
Absolutely, Your Honor.
Now, I imagine everybody wants to speak. On Wednesday, as I said earlier, we had a slot for the Chief Elections Officer who has not appeared and who therefore we anticipate would not be making any submissions. Similarly, the Guyana Elections Commission. Let's see how this will go. Okay, we proposed that the applicants, that's Mr. Ali and Mr. Jagdeo, would go on from 40 minutes, from 9 to 9:40. That Ms. David, that's Mr. Jeremy and Mr. Ford, you would go on from, we give ourselves a little 5-minute break in between, from 9:45 to 10:25. And then we built in some breathing space so that the next slot we have here is a break from 10:30 to 10:45. And then we have the chairman of GCOM from 10:45 to 11:25. And then the Honorable Attorney General from 11:30 to 12 p.m., 12 noon. Then we have a 45-minute break. And Mr. Attorney General, you would note that we have given the principal parties 40 minutes and the parties that are, that the other parties 30 minutes. So I'm afraid.
Yes. Much obliged.
Yes. We would break for lunch at 12 to 12:45. And then council representing Mark France, Daniel Josh, Kanai, and Leonard Schumann. We have 30 minutes from 1 to 1:30. And council for Shazam Ali and Abidin Ali from 1:30 to 2. Then Joseph Harmon from 2 to 2:30. And then we had the reply of the applicants from 2:30 to 3. Now, this schedule I'm noticing assumes that the two amici will not be addressing us, but will put in written submissions. Is there any pressing need, Mr. Amor and Mr. Hossain, why you need to address?
I'm wondering whether Your Honours, yeah, Mr. Hussain fired Hussein,
Yes.
Justin. I'm wondering if you could put into there somewhere 20 minutes for each one of the interveners, as the case may be, because much clarity respectfully could be achieved if we allowed not to supplement, but to supplement in a macro fashion what is contained in our skeletal arguments. I have no doubt the court will be able to follow it, but we need to probably emphasize a few points here and there.
Okay, 20 minutes. Can you do it in 15?
We will we'll try to endeavor our best to do as fast as possible, but 20 on the outside, 15 is the target.
Okay, so we have APNU stroke AFC. They would go from $320.
Your Honours, may I be heard?
Yes. Yes, please go ahead. You probably, no, you're not on mute because I heard you.
Okay. May it please the court, may I be heard, Reginald Amor?
Yes, Mr. Amor.
Thank you, Your Honours. I had thought I had heard, Your Honour, the President say that Joseph Harmon would be allowed from 2 to 2:30. And I took that to intend and to mean a reference to my client, that is to say Harmon Apnu. Did I hear that correctly? Because subsequent to that, Mr. Hussein intervened to reduce the time that you had already allowed me.
No, I see. So Joseph Harmon is your client. That's Apnu AFC?
Apnu, that's correct, yes.
Okay, good. Well, that's fine. That's good. Okay, no.
And I'm happy with the 2 to 2:30 slot, Your Honor. Thank you.
Fine. Then Mr. Hossein, we haven't had a slot for you as yet. Is that correct?
I'm going to invoke the principle of equality of arms and claim as much time as my fellow intervener, Mr. Amor. I try not to take the full time, but I would kindly request that you do the same.
Yes, that's fine. So you would be from 2:30 to 3. We'll go over this in a little while. So the reply of the applicants would be from 3 to 3:20, and then at 3:20 the court will do its wrapping up, whatever that may be. So let's go over it again. The applicants from 9 to 9:40, that's Mr. Mendes. Ms. David, that's Mr. Jenny and Mr. Ford, from 9:45 to 10:25. Then a break at 10:30 to 10:45. Then I see on this we have the Chief Elections Officer, but that person is not appearing. So that frees up some more time.
That would be the chairman of GCOM, Your Honor.
Right. No, we have another slot for the chairman of GCOM. So anyhow, we would.
President, I think I have an updated schedule here. So the break would be from 10:30 to 10:45.
Yes.
Then chairman of GCOM 10:45 to 11:25, which is 40 minutes.
Right.
Attorney General from 11:30 to 12, 30 minutes. Then break for lunch, 12 to 12:45. Then Mark France, Kanhai, and Schumann from 12:45 to 1:15 p.m. Shazam Ali and Abedin Ali from 1:15 to 1:45. Harmon, that would be from 1:45 to 2:15. United Republican Party from 2:15 to 2:45. And a reply of the applicants from 2:45 to 3:15 p.m. and thereafter wrapping up of the case. The only thing is that this will keep us in suspense for the whole afternoon, and maybe there should be a little break in the afternoon.
Right, there was a break in the afternoon, wasn't there?
Well, after the lunch break, I didn't see it.
There's no break. Okay, but we'll have to put in a break. So we would send you the timelines, but the point is that some people have 40 minutes, some people have 30 minutes, and we propose to begin at 9, have a break in the morning, have a 45-minute break for lunch, and another break in the afternoon, and then go until we're complete. Now, we would want now to reaffirm and to restate the order that was given on Monday evening, that the status quo is to be maintained until the court gives its decision in this matter. we will naturally endeavor to give our decision in as timely a manner as is possible. But until we do so, the status quo is to remain as it is on the ground. Is there anything else which Council may wish to raise? Mr. Ramnath?
May it please,
yes.
May it please the court. Your Honor, precisely coming on the heels of the court's admonition that everything on the ground should remain as it is, we have had a situation which I believe the court is no doubt now aware that notwithstanding that a stay was granted of the Court of Appeals decision, certain actions were taken by the Chief Elections Officer which appeared to be in conflict with the stay that was granted. While I recognize that it is the court's intent that everything should remain as it should be, I would be grateful if the court can direct as part of these proceedings that service of that particular order be effected personally on the Chief Elections Officer.
May it please Your Honors.
Yes.
Madam Irfaan, on this matter.
Are you saying something, Mr. Williams?
Yes, please, Your Honor.
Yes.
In relation to the order coming up from emanating from the Court of Appeal hearing, Mr. Khan would agree with me that there was some confusion because the order which came out made no reference to stays simply because the coercive orders that were sought by the applicant were not granted by the Court of Appeal. Those coercive orders are purported to restrain the CEO, etc. And so I suspect that before your order came out, the CEO had no impediment there. So that's why they felt that he could have acted, and they have done nothing since. So, I must say that the President of Guyana has said consistently that he would abide court rulings and elections. I don't think we have a problem.
Okay. Well,
thank you.
Yes. Yes. Did someone check your chambers wish to say something?
Yes, please, Your Honor, if I may. We have ensured that the Chief Elections Officer has been served with all of the papers in these proceedings, including the orders of this court, including in particular the case management order. We reminded him up until this morning that this case management was on, and we also ensured that the link for these proceedings was sent to him so that he would be able to attend. So everything has been done to ensure that he be here, and therefore it is very surprising that he is not. I see that the Honorable Attorney General has thought it fit to speak on his behalf, to provide excuses for why the Chief Elections Officer went ahead to make an order in accordance with what the Court of Appeal has said when he was present. When the Court of Appeal stayed its order on Monday, he was present. Meaning that he was on the call or the link, the video link when that happened. But nevertheless, within a very short period of time, he managed to find his way to invalidating 115,000 votes. I was hoping that he would be here today so that in the event that what he did, as the Attorney General is suggesting, was simply an error or mistake of some sort, that he would tell the court that he would be withdrawing his report because it was done in error, not realizing that the Court of Appeals order had been stayed. Maybe because the Attorney General is taking it upon himself to speak on his behalf, the Attorney General can tell him that what he ought to do, which is the proper thing that he ought to do at this stage in order to maintain the status quo as the Court of Appeal intended, that he should withdraw his report. And after this court makes its decision next week, well, then everyone can decide what it is appropriate to do next. But with this order hanging, this report hanging over all of our heads with 115,000 votes declared invalid all of a sudden, I don't think that it is right that we should continue in this way. As I said, we did all we could to ensure that the Chief Elections Officer was here today, but obviously he has deliberately stayed away. So I'm asking the Attorney General to do all that he could to assist in ensuring that the Chief Elections Officer corrects the error that he made.
Your Honor, I sought to clarify in the interest of justice the remarks made, because I know I was in the Court of Appeals, so I know that that Mr. Kashif Khan admitted that there was some error in entering the order. And as you know, there was confusion because the CCJ had said in the Charandas Prasad Consolidated Appeals that the court wouldn't issue coercive orders against Shikam. So I think there was some confusion there when these interventions were made going to the court. And many people knew that there's no appeal from Article 177. And so that's where the confusion came in, that there was a coercive order claimed by Mr. Mendez that it was issued against the CEO. I think that's where the confusion came. So all these things will be clarified now, but I'm not no messenger or in terms of the CEO. I'm dealing with the interests of justice.
Your Honor, if I may, my client never sought any coercive orders. I don't know what the Honorable Attorney General is speaking about. What we're speaking about is after the court delivered its judgment, I believe it was Mr. Khan had asked for a stay of the order. Mr. Jeremy then intervened to indicate that he was objecting. And the president of the court at that point in time made it very clear that the court was issuing a stay of its order, and it said that it was staying the order for 3 days. The final order that was eventually issued from the court, it contains the stay, the 3-day stay. So I do not know what the Attorney General is speaking about when he speaks of any confusion or any misunderstanding. It was very clear what the Court of Appeal did. And we're speaking about that stay, and we're speaking about the fact that in the face of a clear order of the Court of Appeal given, the Chief Elections Officer proceeded to invalidate 115,000 votes, and then to declare that the government that the Honorable Attorney General represents had won the election. That is what took place. That ought not to have happened.
Mr. President, I'm not sure just how far we can profitably go interrogating the order made by the Court of Appeal. I assume that no approach has been made to the Court of Appeal by the applicants in relation to what the Chief Elections Officer did or did not do. My interest is just to clarify that whatever the Chief Elections Officer did or did not do took place before the order of this court.
Excellent. That's exactly what happened.
And in that event, then, President, I would respectfully suggest that I'm not sure we need to detain ourselves too long on this point. The fact of the matter is that the order of this court has been respected, as I understand it, and continues to be respected. We are not quite clear what happened in the Court of Appeal. And if parties wish to indicate that there has been a contravention of the order by the Court of Appeal, perhaps this is not the appropriate forum for that.
Mr. Keller, did you wish to say something?
My Lord.
Which party do you represent?
John.
I'm not sure if you are on mute, but I'm not hearing you. Was it Mr. Jeremy who wished to say something? I'm afraid we're not hearing you. Who is Mr. Keller? Or the person comes under the name Rondell Keller.
Well, my understanding is Mr. Rondell Keller is junior counsel to Mr. John Jeremy. And in the same way that I am using Mr. Raphael Ajodia's computer, and you probably see me identified by the name Ajodia, it may be that Mr. John Jeremy is using Mr. Keller's computer and may be the person seeking to address your lordship.
Okay, unfortunately, we've lost them. I think that they are probably having some difficulties with the link because they're now not on the call. But what I would say in relation to this matter, we cannot undo what was done by the Chief Elections Officer. If council wish to include in their submissions whether what was done was lawfully done, or whether there is to be no consequence, or whether there is a consequence to what was done, then you're free to do so. But we certainly did not intend, as Justice Anderson indicated, in these proceedings to embark upon the substantive issues, save that we stress, as I did earlier, that the status quo on the ground must remain as it is, so that the fair determination of the issues which have been framed and which are there to be resolved in these proceedings are not prejudiced.
That's a pleasure, Your Honor.
Yes.
We guided.
Is there anything else? Does anyone wish to make any further comment, suggestion?
Yes, please, Your Honor, if I may. I was making the assumption that no affidavits in answer are required to be filed, and we're simply dealing with written submissions.
Yes, yes, you just make your written submissions. Those will constitute your answer.
And I am also aware that the Learned Attorney General has filed an affidavit in opposition. I assume that whatever are the issues that have been raised in that affidavit, we will be permitted to canvass in the submissions.
Naturally. The content of that affidavit will be considered along with whatever further submissions the Honorable Attorney General wishes to make, or indeed if he considers that what is there is sufficient, then he may simply say to us that those constitute his written submissions.
Most grateful. I'm guided.
Mr. Jeremy, are you with us now?
Yes, my lord. Technology. I apologize.
Yes.
I'm not sure exactly where the lordship lost me, but I was, and whether you've dealt with it, but I was making the point that I was to be successful applicant in the court below.
Yes.
That the Court of Appeal issued a stay in respect of the decision of the court at the conclusion of those proceedings. It is not before this court, and in my respectful submission, it cannot be a function for this court to determine what the Chief Elections Officer has done. There's no evidence that I have seen, and Mr. Mendez's statement on his legs about the disenfranchisement of 100,000 odd persons is, in my respectful view, not sufficient to invoke the jurisdiction of this court to do anything with respect to the Chief Elections Officer who is not here. I don't know whether that is deliberate or not, but I have listened and I have heard those motives ascribed to him. I'm not for the Chief Elections Officer, my lord. And I'm mindful of the fact that the Lordship said at the outset that we were not going to get to delve into the issue in any detail. I, as a matter of fact, wish to address this court on the question of jurisdiction, because in my respectful view, I have heard and I have taken careful note of the directions given by the court. But in my respectful view, the question of jurisdiction is not, in this case, to be linked to the sort of question which our domestic courts face all the time in what's called ruled up hearing. We are dealing with a constitution which has an express clause, and an express clause which says that this court has no jurisdiction in matters of this type. And I felt that that point should be taken first. And, Your Honor, Mr. Mendez putting an affidavit on the sole question of jurisdiction today, on the sole question of jurisdiction, making that, in my view, a preliminary point that we had to address before we got into anything else.
Well, Mr. Jeremy, I think it's a preliminary point that you can address on Wednesday. And in the written submissions.
Is that understood, Mr. Jeremy? We do not propose, and I must say this very emphatically, to drag out these proceedings by hearing preliminary points in a serial manner. We will hear preliminary points at the same time as we hear the points of substance. Now, we're all lawyers. We're all experienced lawyers. And there is nothing to preclude us from hearing all of these matters. And then if the preliminary points succeed, then we wouldn't have to delve into the other matters. But if the preliminary points fail, then we would have saved time by already having before us all of the submissions on those matters that go beyond the preliminary point that may or may not fail. So there's no magic in doing this in a serial fashion so that we spend all of the day or tomorrow dealing with a preliminary point, and then you get over it. And then if by chance it doesn't succeed, you have to deal with another preliminary matter. We'll be here until, several weeks. So we wish, as I said at the outset, to receive all the submissions, and we are going to consider them just as carefully as if they were substantive points, and if they are points which would require us not to embark ultimately on the substantive issues, then it would be futile and we would not embark upon the substantive issues.
Your Honor, if I may?
Yes, sir.
I'm conscious of the constraints which you also has placed on us at the outset. That is the I'm mindful of the fact that the Lordship said that we want to get bogged down today with more than the bare essentials, case management. But Lord, it would be remiss of me, now that my learned friend has, Mr. Mendes, has embarked on what we decide to be tangential issues, to fail to point out to this court that statements are being made by persons outside of this court with considerable influence in the region, which impact on the decision of the Court of Appeal, and which have the potential to impact on the decision of the court. I just point that out. I go no further than that. I ask you to do something as Mr. Mendes had requested. I just made the point that these things are being done and said, and that is unfortunate because we are, as your Lordship said, we are all lawyers. And this is a matter of the utmost importance to the people of Guyana, and it should really be settled. The people of Guyana should have the confidence that this matter is being settled in this court.
Yes, thank you. And you can rest assured that the bench is going to treat with this matter only on the basis of the material that you and your colleagues, those with you, those against you, those who are in this court today, on the basis of what you submit. And that is what is always done, certainly by this court. So you can rest assured that we are not going to have regard to anything which is being said outside of the court and which does not feature as a relevant part of these proceedings. Now, as I said at the outset, today we didn't intend to get into, perhaps I opened the door to all of this by stressing, but I thought that it needed to be stressed that we wish to have the status quo remain. And we don't wish to see or hear about some things being done that will prejudice the fair determination of the issues that you have all placed before us. We will endeavor to get you the orders that we've made today. Did I hear someone wishing to say something? Okay, we'll endeavor to get you those orders this evening. If I could just rehash them very quickly, we have agreed to allow APNU AFC and the United Republican Party to intervene in the proceedings and to make submissions. We will treat all of the claims, objections in one proceeding. We have an omnibus hearing on Wednesday. We will receive your written submissions pursuant to a timetable which we would give you. I had set out that timetable earlier. And then we will hear your oral submissions on Wednesday in keeping with the timetable, which we hope to be able to give you in the order that would follow these proceedings sometime this evening. I wish to thank you all for proceeding in this fashion. Mr. Jeremy, your internet, we weren't hearing you very clearly, and perhaps you need to consider whether on Wednesday you will be using the same device or from the same location, because you certainly were not as clear as some of the other council were.
President, may I be permitted a gloss on your concluding remarks?
Sure.
I would like to express the very firm conviction that all counsel will convey to all persons who may listen to them that this court has not decided it has jurisdiction. Thank you.
Yes, yes, that is something which we will only decide after we've heard all the submissions and made our decision on that matter. So that the fact that we've had this case management conference, or that we are making orders to receive submissions, is not to be taken as if we have already decided the issue of jurisdiction. It is an issue which we have to decide. In order to decide it, we have to put in place certain management processes and receive your submissions. And that is all that is being done up to this point. So, Council, we will hear again from you on Wednesday. You are to log in at 8:45, I think it is. And we shall proceed to hear the matter and keep it with the timetable which we will let you have. Thank you very much for appearing this afternoon. The bench will now take their leave. Madam Deputy Registrar, you can bring the proceedings to an end.
Thank you, President. This court stands adjourned. Thank you.